Good morning, good afternoon, good evening. Welcome to the launch of the Africa Rule of Law series, a forum dedicated to examining the rule of law across different countries in Africa. My name is Adaobi Egboka. I direct the work of the Vance Center in Africa. This series is organized by the Cyrus R. Vance Center for International Justice, the New York City Bar's African Affairs Committee, and the International Human Rights Committee, the Pan-African Lawyers Union, and the Robert F. Kennedy Human Rights, on whose behalf I welcome you all. We acknowledge the importance of rule of law to democratic governance, economic development, and social justice. In Africa, we have seen gains in establishing legal frameworks that promote justice, accountability, and human rights. But challenges still remain. We see weak institutions, political interference, corruption, limited access to justice, and more continue to undermine the rule of law in many countries. In view of this and all that is happening across the globe, we decided to launch these periodic discussions on the rule of law to provide information on topical issues in Africa and create a forum for discussing these challenges, brainstorm issues, and mobilize action from different actors. Today, our focus is on Uganda, really using the ongoing trial of Dr. Kizza Besigye to discuss the principles of justice and military trials in the continent. The trial of Dr. Besigye poses several rule of law issues, and that's why we thought it was a good one to start with. First, the use of military courts to try civilians, particularly in politically sensitive cases. Second, the alarming rise in cross-border adoptions and extraordinary renditions, a troubling trend in the continent. And third, the repression of legal advocates and human rights defenders. Dr. Besigye's attorney, Aaron Kizza, was sentenced to 9 months in military prison and was released 87 days after of detention. But unfortunately, none of these issues are isolated to Uganda. So from Cameroon to Egypt, from Rwanda to Zimbabwe, we see similar tactics being used to stifle dissent, evade legal safeguards, and silence legal practitioners. So what is our goal today? Our goal today in today's section and in every section that will follow in this series is really to not just simply critique, but to inform action, mobilize support, and at the same time, rally everybody to find ways to support. We've designed the sections to be informal, but very informed space. You will notice it's a regular Zoom meeting, and the idea is that we really want everybody to engage actively and not feel left out. Please feel free to use the chat box, raise your hands, and let's have an interactive discussion. Today, I'm joined by 3 distinguished voices, each with deep experience in law, governance, and human rights. 3 of them will help us unpack the legal, constitutional, and regional implications of this case. I don't think they need any introduction. We'll put their bios in the chat box, but I'll just go ahead and briefly introduce them. I'm joined by Honorable Karua, a respected lawyer, politician, long-standing advocate for constitutionalism, human rights, and good governance. She served as the Minister of Justice and Constitutional Affairs and has been in the forefront of legal and political reform in Kenya for decades. I also have with me Professor Chidi Odinkalu, a Nigerian human rights scholar and former chair of the Nigerian Human Rights Commission in Nigeria. It's a prominent voice on the rule of law, democracy, and justice across Africa, and has worked extensively with international organizations, governments, and society on human rights and legal reform. Professor Chidi is a senior brother to me and was mentioned. I also have Dr. Kabumba, a Ugandan constitutional lawyer and lecturer at Makerere University School of Law. He's a recognized scholar on governance, transitional justice, and constitutional development. He brings deep expertise on Uganda legal system. I'll kick off now by allowing my panelists to be unmuted and pinned on so that we can see them. Okay, I'm told that Dr. Kabumba can show his video, and Rumata will soon join us. But thank you so much for joining us today. We're really excited to have you. We know how busy you are, and to imagine that you agreed to be here. I'd wanted to start with Honorable Martha Karua to really give us an idea of the case and lay foundation for the case. But since I see she's joining late, I will move to you, Dr. Kabumba. We know that the Supreme Court of Uganda has, at this point, ruled that military courts cannot and should not try civilians. What do you have to say? And we know that the president at this point also openly rejected the Supreme Court's ruling. What does that say about the constitutional supremacy of Uganda today? And what's the hope for others and then for future cases?
Thank you very much, Adaobi, and it's a real pleasure to be here with the team from Vance, colleagues from Palu, NYC Association, and RFK and others. I see, certainly, of course, Martha is going to join us shortly, but also Prof. Chidi Odinkalu, a towering voice. It's a real pleasure again to be on this panel with you. I also see a number of friends and colleagues from Uganda, so I think my task will be much lighter since there are very many voices that can quickly jump in to provide more input. Particularly, I see that we are joined by Aaron Kizza. I'm sure his experience will be critical here. And perhaps he should have been the panelist. So, Aaron, my apologies. So I'll just work as the curtain raiser for this, and perhaps I'm sure we'll have a very important conversation. Now, in terms of the question as to where we are, I think in Uganda we are where we've been for a very long time. I wrote about 13 years ago now, I think, an article called The Illusion of the Ugandan Constitution, in which I suggested that the Constitution of Uganda is at best aspirational, but at worst a collection of fairy tales, basically a book of lies that begins from the very first article, which says this, all power belongs to the people. Article 2 that says the constitution is supreme, and the lies just keep going on and on, where it suggests that the army is subordinate to civilian authority, that there's a parliament, that there's a judiciary, etc. All of these really have increasingly been subject to challenge. So even where we get wins, such as the Supreme Court decision in Kabaziguruka, that has to be placed in a broader context. And it's a discussion we had with Prof. Chidi a couple of months ago now at the Rule of Law series hosted by the Ugandan Law Society and the Human Rights and Peace Center, in which I think we made the point that there's a crisis of judiciaries, certainly in Uganda, in the region, across Africa. I guess the point is also made in Nigeria. Who knew that you would also have a crisis of the same proportions? So, well, perhaps not the same proportions, but certainly challenges in terms of the executive and judiciary, also in the United States. Perhaps we may also talk about that. So, the point really is that this latest rejection by Museveni of the Supreme Court decision must necessarily be placed within the broader context of the absence of meaningful democracy in Uganda, the facade, an illusion really of democracy that has been well crafted for a long time now, and I don't think many Ugandans now have any more doubt at all as to the reality of our governance, which really is a military government that has a civilian face and that will, make a couple of nods once in a while, provide a number of gestures to constitutional democracy, but in actual fact remains at its core a military regime that has just the very thinnest facade of democracy. So really, it was only to be expected that the decision of the Supreme Court would be so robustly challenged. It was actually itself surprising that the court, I think many Ugandans were surprised at the decision, that the fact that the decision itself came out that way. But that does not even absolve the Supreme Court itself. This was a decision that was over 5 years late. So it was itself was a crisis, in part contributed to by the Supreme Court. But critically, we're partly where we are today because the Supreme Court, the Constitutional Court, and many courts in Uganda have, at critical junctures, failed to safeguard critical guardrails within the 1995 Constitution that might have forestalled a worsening of the situation. I'll just give one example. When in 2017, the very last check to an imperial president in Uganda, when the constitution was amended to remove presidential age limits, that was challenged before the Constitutional Court and Supreme Court. And at the end of it, both courts found broadly that the amendment was constitutional. So really, from that moment onwards, there's nothing to protect us anymore from the reality of an emperor, president, who will then pass on power to his son, crown prince by all indications, which power will be basically vested in an army. And I'm conscious about time, and I'll just say just this in 1 minute, that many Ugandans now look more or less helplessly on because both the president, his son, the wider family clearly have control over the army. Now, a few days ago, we were treated to even more depth in terms of how far this might go, where the first son and the chief of defense forces very casually admitted to having in his basement, as he said, the bodyguard of Honorable Bobby Wine. He had a beard that had been shaved, and he was very happy to share the photograph. He talked about the clear torture that this gentleman was going through. So the idea that now in Uganda, torture is being live tweeted by the first son, who also is the chief of defense forces. Things were bad before, but things are really bad now. And I guess it's anyone's guess. I suppose things will get very much worse before we even have any hope of those things getting better. Thank you.
No, thank you so much. And I know that the elections are coming up next year. So this may just be the beginning of many things that we're going to see come up as the months go by. There's so much to unpack in Uganda, especially not just for the military trials, the new legislation that is going to be proposed about the use of the military courts. And then now we saw what happened over the weekend with the blessed son, as you call him, or the appointed or anointed son. I'm going to hang in there because I want, if Honorable Martha can come and lay the foundation so we can have a deep dive in what is going on in Uganda. I'll just invite Professor Chidi so that it won't be like we're just only focusing on Uganda, to spotlight what else is, because we know that this is not just in Uganda alone. this case in Uganda reflects a broader pattern in Africa. We've seen this happen in other countries. Professor Chidi, please, can you at this point explain to us how widespread is this use of military justice to criminalize dissent across the region? Which other countries do we see this happening across in Africa?
No, thank you very much. And can I please also join Dr. Kabumba in saying thanks to both the Vance Center and to the other colleagues who have joined us for this conversation. Let me say, first of all, that I honestly, I'm not sure that there is any other country on the continent that has a Muhoozi Kainerugaba. Okay, Muhoozi is unique to Uganda. And in that sense, I guess Uganda has to be proud of its unique brew in him, and and his dexterity with X in particular is extraordinary. But we'll get to that in a moment. In terms of the use of military tribunals across the continent, I think it's fair to say, again, to some extent, what Uganda does, or what President Museveni in particular and his retinue do with military tribunals, well, is a little unique. It's not by any means the only country in which there are efforts to expose non-military personnel or civilians or non-combatants to military justice. But I think Uganda is unique in the extent to which it tries to use it. I don't, some people here may remember that about 7 years ago, 6 years ago, oh, well, 7 years ago, actually, Cameroon put to trial some exiles who had been refued from Nigeria, for instance. They were subjected to military trial in Yaoundé. All of them were civilians. Many of them were professors who were refugees in different countries who had attended a meeting in Nigeria. They were rounded up there, sent across the border to Cameroon, tried by military tribunal, and then sent to jail. They're still at the Kondegi maximum security prison in Yaoundé. And the several entities, including indeed the High Court in Nigeria, as well as the UN Working Group on Arbitrary Detention, have found that contrary to and incompatible with lots of international instruments, but that's not precluded Cameroon from still keeping them in detention. In North Africa, of course, Egypt still retains military tribunals for certain categories of offenses involving civilians, I believe, and Tunisia as well actually does too. The notion of revolutionary justice, of course, with a lot of countries that have been through liberation movements, means that sometimes the borders between military justice and regular justice sometimes are very tenuous. And that basically is really the origin of what you have in Uganda, because the UPDF, what is now the UPDF, began as a bush movement, as a guerrilla movement. And those boundaries have, you know, having taken power, by the way, since 1986, which is eons ago, um, the NRM, which then became, or the NRM and its military wing have really refused to do what is necessary. I may add one more thing, which is Nigeria actually used to do the same thing. In I believe 2018, the ECOWAS Court of Justice struck down efforts to subject civilians to military justice in Nigeria, admittedly under military rule, which ended in 1999. Zimbabwe, actually, I believe this the Zimbabwean Chief Justice used to be a military judge advocate. And of course, there are controversies as to whether or not his tenure continues, but that's a different matter. So there are all manner of infiltrations here and there that we find across different countries in Africa. But I think I should stress the point that the very extensive use of military tribunals for civilian purposes and the resistance being mounted by the regime in Uganda is rather unique. I think it's fair to say. Can I yield?
Thank you, Professor Chidi, for the trend that you've shown and the acknowledgement that, and we know about the unique situation in Uganda, which is almost unprecedented in the continent, but noting that there's also the issue in Cameroon, in Egypt, in Tunisia, some time ago in Nigeria and others. It's a good thing to know, and then to see where are we today and the level at which it is still being used in Uganda. I'm going to come back to you, Dr. Kabumba, but before I do, I also want to mention that the idea of this series is to have a conversation. And in the chat, I see in the list of participants, I see many people I know that are very, very aware of this. Aaron Kizza, thank you so much for joining. I want to acknowledge you because I know that you are a core victim of this. And we're glad that you were able to join. So anybody, please feel free at any point to raise your hand, put a comment in the chat. We want this to be a conversation as we go along. I'll go back to Dr. Kabumba to really look at the Uganda situation. There's an acknowledgement that is unique and is unprecedented. So I'd like us to focus more on it. What do you see? We know that now that there's a new legislation that is being proposed, we hear that there is advocating for legislation that allows military trials under exceptional circumstances. What does that mean? And what is the legal status of that? And where does that place that legislation vis-a-vis the Supreme Court ruling? And how can we help? How can the legal international and regional community respond to this? What are your thoughts?
Thank you very much. Yes, there seems to be rumors of a new bill, an updated bill to amend the UPDF Act. There was a bill before Parliament before, a 2024 one, but that has since been withdrawn. And that being planned has not yet been published. So we have there are some reports of what might be in the bill, but it's not quite clear yet as to the exact content. It could be that there's a discussion going on around the implications of being in such clear contempt of the Supreme Court ruling or the Supreme Court decision. That's really a best case scenario. But nonetheless, if and when it comes before Parliament, that of course will be another opportunity for a very vigorous debate. Now, the Supreme Court did offer guidance as to what it saw as the clear challenges around military courts, the lack of expertise, of those in those particular courts, the question around the Constitution and what it had envisaged, the idea that those courts really were meant for as disciplinary committees for military persons as opposed to being sites for the trial of civilians. So the challenges I see it is that the state seems to think that there's scope for amendment of the act in a way that would make it consistent with the Constitution. That would be that's a significant error. It seems either the president is either being misadvised or is incapable of being advised. Somewhere, the truth is somewhere between the two of those things, because at the core of the Supreme Court's decision was a clear demarcation between the space for civilians, the domain of civilian authority, and that of the military. And even the court went as far as saying, reflecting on the idea that even for soldiers, there are aspects of military tribunals that cannot be said to meet the requirements of a fair trial, including the tenure of the members of the tribunal who serve under different capacities, their competence, their expertise, etc. So any bill that goes against the spirit of that decision would likely be challenged. So again, there are islands of resistance, and within areas of the, even within and I guess this not perhaps not unique to Uganda, that however dark a situation is, you'll have professionals, even within the army, even within the police, even in the Attorney General's chambers, in Parliament, and elsewhere, who retain a sense of professionalism, but also a sense of shame. The awareness that there are lines that cannot be crossed or should not be crossed, and the sensitivity to legitimacy. And I suspect that some of those voices have been what has kept us from the brink. Prof. Chidi has alluded to the very unique Muhozi, and I hope we can discuss that at some point, that factor that might take us past the brink and collectively, in a very unknown territory. But so far, it seems there are some rational voices that have sort of kept things within from getting bad to worse. That said, if and when the proposals, in whatever shape or form, come to light before Parliament, I guess that will be the time for voices of goodwill across within the region, in Africa and beyond, to join us. And I guess I think a very good example has been the intervention by Martha Karua, both in the Besigye trial, but also in the subsequent proceedings that involved Aaron Kizza. That really brought a spotlight to those really sham proceedings. Martha Karua, the involvement of PALU, the East African Law Society, that certainly made it clear to the various actors, including the courts involved, that their actions were being examined by actors outside Uganda, and it might have led to a modicum of restraint. And I've said this elsewhere, I think to the extent that there seems to be a cooperation, perhaps in some cases even collusion, between states and governments that seek to roll back years and even decades of democratic progress. We've seen that in East Africa with what's happening in Tanzania now with Tundu Lissu, in Kenya with the abductions of Besigye and others there. So if those governments, if repressive governments are cooperating, it seems to be just logical that those who would push back should similarly cooperate. I see Honorable Martha Karua has joined us, and it's a very good point for that. So I really think that it's just a question of logic, that it just simply makes sense that if there's this coordination at that stage, there should also be coordination at this stage. Thank you very much. I think I'll leave it at that for now.
No, thank you so much for that deep explanation, and the idea that even though the Supreme Court has provided guidance on the issue, and there is the attempt to introduce this bill, and we're talking about engagement, discussions, is really scary, being that the Supreme Court is the highest court in Uganda. And we're all watching and eager to know how we can support if this bill scales through to the parliament, because we're not even sure of what the parliament will do at this point. But we have seen the huge difference that the international voices that have come forth in these discussions in the trial of Besigye that we have seen has yielded in Uganda. So we're hoping that, keeping fingers crossed and wanting to get out key points. So many of us who are on this call and thinking about how can we support as legal practitioners, as donors, as regional actors, how can we support Uganda? That's something that we really want to get out before we end this. But I see that I've been joined by Honorable Martha Karua, and I see her apologies that she was caught up in something else. We're really grateful to have you. Thank you so much for joining. And I think I'll come to you immediately, because there is foundation that needs to be laid for many people who may not know full details of the trial of Dr. Kizza Besigye. You are the lead counsel on the case, and this has been the most recent, because there has been so many in Uganda, of civilian prosecution in military tribunals in Uganda. It would be great for you to just outline quickly for us the facts of the case, the legal issue, what is the current status, now that we have the Supreme Court ruling, where are we, and what institutional safeguards is necessary to prevent this executive overreach in similar cases that may come up in Uganda or elsewhere.
Thank you very much, and sorry I logged in late, and but I've heard what my colleague was saying. The brief facts of the Besigye case is that he came to Kenya in November last year. As a matter of fact, coming for thing, he was abducted while in Kenya by both Ugandan and Kenyan security. The Ugandan ones, we now know they were from the military. The Kenyan ones, we don't know, but it was a group of 8. 4 went with him and Obed Lutale up to Uganda, and they put them in military jail. When passing through the border point between Kenya and Uganda, they had no documents, and no documents were stamped. So literally, they could have been disappeared without any record. Their passports were left in Nairobi. After word leaked out that they were in military, 2 that fact. And immediately that tweet came out. That Monday afternoon, because they were abducted on a Saturday, that Monday afternoon, Tuesday actually, not Monday, they were taken to a military court and charged with the trumped up charges, possession of guns, wanting to overthrow the government, etc. Thereafter, we talked with the family and with the lawyer in Kampala, the Lord Mayor, and we agreed that I go over and lead. I had to apply for a practicing certificate. First, I was denied, called names, but I didn't go. We bounced back and applied with the support of the Law Society of Uganda, Law Society of Kenya, East Africa Law Society, and a lot of civil society who had spoken out and demonstrated. This time they gave me the license. In the military court, obviously, they do not follow due process. The entire panel and its chairman are military men. Yes, there is a judge advocate who is a lawyer, but his behavior left us convinced that law had left him and he was just like the other untrained military men. They were listening to one side, and somewhere in the middle of our appearances, one of the Ugandan lawyers, a young lawyer, Aaron Chisa, who was vocal, was attacked, assaulted brutally in court when he was trying to get access to the bar where he could sit and work with us as a lawyer. He was then convicted without trial for contempt of court, jailed for 9 months. And he has just been released after spending almost 3 months in jail. That tells you what sort of court, what court watches when its orderlies are brutalizing someone. That tells you what type of a court these military courts are. Due process means that you're being tried by impartial people. It also entails people who are well-versed in law. We will protect the rights of all the parties in court, not one party. A military tribunal like the one in Uganda, the commander-in-chief is the president of Uganda, and the chief of general staff is his son, who is the CDF. And the son keeps on making threats on Twitter that they will hang Besigye this month, by the way, May. And he even says where they'll hang him, in a tree in Gulu. He says so many things. And you can see exactly that they have some control of the courts. Because when we applied for bail, bail was not given. He had already said they'll never release him. So the impression is that the courts are being controlled. And the way the courts were behaving, even in the case of Aaron Kizza, for Kizza Besigye and Lutare, there can be the pretense that there is pending charges because he has now been charged in a civilian court. But for the lawyer Aaron Kizza, nothing was pending. There are no charges. Yet the courts were unable to release him. He is actually released on bail, a 10 million bail. You wonder bail pending what? And there are no charges. And the court that convicted him was found not to be competent. So this is the kind of situation we are in. And I can tell you, as the lawyer, one of the lawyers in the case, we are not going to win that case by our arguments in court. It will be by sheer pressure. So the amount of people contacting the authorities in Uganda about not following due process, because Uganda has violated, first of all, Kenya violated its constitution by renditioning Besigye without a court order. Our Extradition Act demands that there must be a court order. The East Africa Community Constitutive Act, one of the foundational principles is the rule of law principle. So we ought to have gone through due process. And also international norms. Uganda too has violated its constitution, which is similar in those human rights and whatever provisions, the Bill of Rights. They violated their own law by coming for Besigye in Kenya. And you wonder if they really had charges, why couldn't they pick him up in Uganda? Kenya has been renditioning people, including refugees who were here legitimately as refugees, Turkish nationals, against the refoulement principle, taking them back to Turkey. Nobody knows how they are. Renditioning people from Ethiopia. Another group of 36 Ugandans were renditioned last year in July. They belong to Besigye's party. They were just in one part of Kenya called Kisumu, having a meeting. They were arrested and renditioned, and they were taken to the military trial. Now, I am happy in Uganda, Parliament, after some time, human rights even visited him in prison, discussed the matter in Parliament. The Uganda Human Rights Commission also went to see him, but not one that would even be a notch higher. We are pleased that the opposition parties, both in Parliament, have been coming to join us in court. We're also having people from various countries. We've had a lawyer from the Comoros, from Angola. We have had Palu, New York Bar represented by members of Palu. We've had a mixture of people, and individual lawyers from Kenya and Kenya Law Society has also been in the matter. And even in Tanzania, they have now joined us, where we are observers in the case of Tundu Lissu. So there is an emerging pattern in Kenya, Uganda, and Tanzania, where it does appear like they are collaborating to oppress. And recently, this year, Maria Sarungi, a journalist and activist, who resides in Kenya because she sought safe haven away from Tanzania, was abducted. And it's only that she fought and the information got out in time. There was such uproar by Kenyans on Twitter and other people behind the scenes, and she was released before being renditioned to Tanzania. So this discussion is timely, and it shows that we need solidarity within our individual countries and solidarity beyond the borders. And we thank all those who have stood with us. Chidi, your article was very timely, Professor. And all those go to help in applying pressure. I don't know whether I have answered all your questions.
You have extensively. And I know you have more to say about this because this is a very sad reality that we find ourselves. And the idea that not just Kenya, Uganda, national and international norms are just being violated in Uganda and nothing is happening. And it's just so sad to listen to the trend that we have seen, the situation with Dr. Besigye and the common trend of rendition that we're also seeing in many countries. I will run to Professor Chidi. I'm glad you mentioned him because I know that he has done extensive writing on the judiciary, not just in Nigeria, but in a lot of countries. And just thinking, Professor Chidi, what does this, because our goal is to create awareness on this platform, but also then find what can we do differently and what are the trends, what are the opportunities for us to engage. And that's why I'm asking, what is the situation in Uganda? We already know what it reveals about judicial independence, but what reforms do you see? Fair trial, limit executive power, and maybe protect judicial autonomy. What are you seeing? And then we're also talking about the idea of protecting lawyers from political reprisals. We see Aaron Kizza is on this call, and we know how many days, 80-something days spent on detention for nothing and granted bail that we're not even sure where that will lead us to. What are your thoughts, Professor Chidi?
No, thank you very much, Adaobi, and even more to Honorable Martha. When you talk about what can be done or reforms, it's actually about us. Okay? To have a senior lawyer like Martha Karua, senior counsel, lead this, even from across the border, changes things. There's only so much young lawyers can do when senior lawyers are not willing to provide leadership. And across our regions, sadly, across our countries, East Africa, West Africa, wherever you look, a lot of senior lawyers are complicit in this madness. And if we're going to change it, it's going to begin with the point that Honorable Martha Karua has just made here, which is what? Solidarity. That's the first thing. And ethical leadership by senior lawyers. Seniority comes with responsibility as an African coexistence proposition. Seniority comes with what? Responsibility. We don't call our elders by their names. We call them by titles. That's because they earn it. And when that comes, you accept the obligations that come with it. The first thing, therefore, is those of us who are 30 years at the bar, 40 years at the bar, and beyond have got to take leadership and take the responsibility of leadership seriously. And I can't say it enough. The courage that Honorable Martha Karua has shown in this is utterly exemplary. If we could get 3, 4, 5 senior lawyers across the continent doing something similar, that would make a difference. So that is one. The second thing is the solidarity across boundaries, therefore. And PALU, in this sense, and the East African Law Society are showing us a model. In West Africa, the WABA is struggling, the West African Bar Association, and I think we can do a lot better about that in trying to get the regional bar associations take this seriously. The exposures that we're all going through across the continent on rule of law issues, I think we need to do better with cross-border solidarities. And the WABA umbrella can also help in fostering that. To be fair, what Palu has been, sorry, the Palu umbrella, Palu has been doing that with passion, and I don't think we can give up on that. So that is very important. I don't think we can rely on countries to reform laws for us on this. We are going to have to force them to do it, and to force them means also we're going to have to exact costs on their sovereign reputation, costs on their transactional reputation, costs on their institutional reputations, and costs on their diplomatic capital. That's going to come from organizing. And that organizing is not just going to be done by younger lawyers, it's going to involve those of us who are a little more senior than a few years at the bar. And that also includes people like you at Vance Center and the kind of thing you're doing here. Mobilizing also with several other actors across the board, including the special rapporteurs on independence of judges and lawyers in New York, but also the new mechanism on independence of lawyers and judges, South African Commission on Human and People's Rights. We've got to explore, there is a lot of litigation at the moment actually taking place on these issues, whether the African Court on Human and People's Rights or the rule of law provisions in Article 27 of the East African Community Treaty, which will take some time to walk through the system, but which are needed in order for us to make progress. When we get, as those work their way through the system, I think we are then going to have to begin to go back to countries in terms of what can be done, to make those international law. But I do think ultimately the first thing is the leadership of senior lawyers and the solidarity amongst those of us who are interested in this. Thank you.
Thank you, Professor Chidi. I hear solidarity, and not just that, but from senior lawyers, and your emphasis, I know you've had a lot of write-off on not just the judiciary, but also the bar, and the role that senior lawyers on the continent can play in these issues. I see somebody in the chat talk about the Iron Lady of Kenya, and we are glad that Honorable Karua has really earned her place in really being a voice on this issue. And that brings me to you and Honorable Karua again, before I go back to Doctor, to really ask you, one other thing that came out from this case was the issue around reprisal of lawyers. We saw the imprisonment of Aaron Kizza really show the limitations to civic space. It really shows a lot around lawyers defending political opponents. And then we saw how the bar associations came forward. I know Professor Chidi has really outlined the idea of solidarity, both from senior, from bar associations. What else do you have to add to it in terms of experiences of reprisal for both legal and political actors, especially for lawyers who handle this kind of cases?
It actually confirms that repressive regimes will even go after the lawyers because they want to isolate these people, the people they are after. They want to take them through a sham trial, and they see lawyers as obstructing the speed with which they would like to finish the task. Aaron was one of the most outspoken lawyers, engaging the military court and the prosecutor. And I think they had marked him because they even, in the sham ruling, they said that he had done something else 2 weeks before. So he was being targeted. And that's why the orderlies were preventing him from proceeding to sit, to find an excuse to now assault him and later get him jailed. I would want you to know that on that day, we were 42 lawyers for Dr. Besigye and Bedlo Tale. After Aaron's assault, 20 vanished into thin air. When we were doing a count again, we were only 23 in court. Today, as I speak, the last time I was in Uganda, which was 2 weeks ago, we are now 13. I don't blame those young people because majority are young people. You go to court to help. hoping to go back to your family and to your practice. When this happens, it throws everybody off balance. And I know Aaron will not complain, but I know this has affected him, affected his practice. He told me even some clients just left him because he's now a marked person. So how can we have solidarity? And as Professor Chidi says, if we have senior lawyers, they may not be very quick to do what they did to Aaron, to a senior lawyer. I was threatened and called a foreigner in court and threatened with contempt of court. But you see, he will not easily put me off. I reminded him that I too had been a judge advocate in the course of my career. And I told him he was not behaving the way he's supposed to behave. So with me, they were handling me differently, not the way they were handling Aaron. So I do agree that solidarity by both young and especially senior lawyers to lead this. And I want to tell you, I've seen senior lawyers in Tanzania when I went for Tundu Lissu's case. It's being led by senior lawyers, but there are many other lawyers. And that's really very good because they give each other courage. But when you are so battered, like they have battered the bar in Uganda, that some of the lawyers are almost being apologetic to the court. In fact, I had a discussion, and I'll not reveal with who was suggesting when Aaron was in jail that perhaps Aaron should apologize in order to get out quickly. And I wanted to know what they meant because he was assaulted. He was prevented from accessing the bar. He did nothing wrong other than to raise his voice and say, I will enter repeatedly. He did not assault anyone. So for what was he going to apologize? For being assaulted or for being obstructed? But you can see that psychology, it's that people have been battered psychologically, physically, until you believe every time something happens, you blame yourself. I'll tell you that on the plane back to Kenya, I and a colleague who had accompanied me, we were wondering what we could have done to stop the assault. I felt guilty, like I didn't protect a younger lawyer. And when I came back to Kenya, I talked to the president of the Law Society, and I told her that what has happened in Uganda will have implications on the bar in the region. And she got it and immediately deployed an observer in the case. And they have on their own motion deployed the observer again in Tanzania. Tundu Lissu is a lawyer. So solidarity among lawyers, solidarity when the bar is attacked, and for you to know that this thing has had real effect, the president of the of the Ugandan Law Society was having a tiff around that time with the court. He uses flowery language to make the point. Not everybody may agree with that language, but I see his point because sometimes, unless you are provocative in the way you put it, repressive regimes will not respond. After this Aaron's case, they have sentenced the president of the Law Society of Uganda to 2 years imprisonment. Remember, contempt normally is 6 months. And there are multiple warrants out for him. And it's again without trial, forcing him to remove himself from that atmosphere to elsewhere. This really is something that, as the bar, we must take very seriously. There is repression and there is obstruction and intimidation of lawyers who go to represent. I found a colleague already informing you that in Uganda, they are now trying to amend the constitution to defeat the Supreme Court judgment which said civilians should not be tried in military courts. They want to amend the constitution to give power to military courts to try civilians. What can we do? Professor Chidi mentioned regional institutions, or it was you. And I want to say that we have written on both cases to the African Commission on Human and People's Rights. And we really must ask regional institutions to account for what do they exist. Since we brought to their attention these matters, I would want to know whether they have made any communication with Uganda, whether they've made any resolution. We have copied letters to the AU for leaders to protect themselves. South Africa, no response. Actually, I can only commend the East African Court of Justice because it does that. But there's 1 year it did not do any work because the bat was the powers that be are not happy, perhaps with the judgments. So we've got a basket full. And how solidarity, we formed Pan Progressive Leaders last year, and we were able to put pressure and to call for support on Senegal's issue. We are doing the same on the heads of that organization, apart from representing Besigye. And one would wonder whether we can broaden solidarity across the continent so that we are inundating them with letters calling them out. We are holding forums that call them out because I know they hate to be told. We had the Commonwealth contact them, seek to come and observe, and they refused, they just did not communicate. And you know, Commonwealth cannot go to a country without permission. It's a governmental body. So I know pressure works. So let us see how we can stand in solidarity, because this is a common problem now in most of Africa. Yeah, thank you.
Thank you so much. Thank you so much. Just listening to you on the chilling effects of this whole issue on young lawyers and even the legal practitioners themselves is scary. And I like the idea, the way you have called our regional institutions. There are so many different groups coming up now, the Arusha Initiative, so many other ones, to ensure that there is a lot of checks and people watching on what is happening in the regional institutions as it relates to not just the rulings that come out, but the issues that are brought before them. So thank you so much for that. I see that we're winding down, so I'm opening it up for the chat room. Please feel free, raise your hand, drop a chat, and then we can come to you. I have tons of questions here. There's so much to unpack, but I'm mindful of time, and I promise we're going to stop right at the time. I see a question in the chat, and that's for Dr. Kabumba. I was going to come to you too. I'm going to pair the two. And it talks about the disturbing scenario that we are seeing, that the court has granted bail to Dr. Besigye and his co-accused. And despite that, nothing has happened. What other legal channels can be explored? In answering that, please could you also connect it as we talk about, Professor Chidi has talked about senior lawyers and the way we can seek solidarity for them. What do we do? You are in the education sector, and I know you've written extensively about these issues. How should the legal education in Uganda and across Africa evolve to better equip lawyers? Because yes, senior lawyers has a role to play, but you are in an institution that is building young lawyers. How do we mobilize them? How do we support them to confront this kind of challenges in the future? You're preparing the next generations. What opportunities are there, or what are you thinking, or your thoughts on that?
Okay, first, sorry.
Was that for me or for Honorable?
No, it's for you, Doctor.
Yeah.
All right,
Okay,
thank you very much, Adaobi. Just to say, first of all, I'd like to also pay tribute, really. I guess the question of senior lawyers has come up, and I'd like to pay tribute to quite a number of really senior lawyers in Uganda who have stood up to be counted at this critical moment. In fact, one of them is right here on this chat. Philip Karugaba, really one of the finest we ever had. A gentleman who taught me civil procedure, I think about 25 years ago now. When I say that, I sound and feel quite old. But you have Philip Karua, who has really led efforts not just around the Kawaziguruka case, but also Aaron Kizza and others, and most recently led quite a number of lawyers in writing a letter to the Human Rights Commission that actually I think was quite instrumental in having the commission issue a release order. This in respect of Eddie Mutwe. I don't know if I see Karagawa is still in the space. But in addition, you have quite a number of people like Francis Kimara, Bruce Cherere, both of them former presidents of Uganda Law Society, Wande Rogalo, Peter Walubiri, and really quite a number of other senior, really senior lawyers in Uganda who have historically fought for the rule of law and good governance in Uganda and are continuing to do so, according to turn up and show up, Nicholas Opio and others. And so I'd really like to pay tribute to those men and women in Uganda who have, who might have sat back at this critical juncture, who certainly have earned their retirement and could be doing very many other things, including holidays in the Maldives, but keep putting their necks out to ensure that the semblance of democracy and governance in Uganda that can be salvaged is salvaged. I'd really like to acknowledge them and really pay tribute to their efforts. But now, in terms of what can be done regarding legal education, a couple of weeks ago, I received a very instrumental book by Chief Justice Emeritus of Kenya, Willy Mutunga, on radical legal education and detailing his experiences in Kenya and those of others. And I think that might be the way forward. I'm privileged to teach, and for the past almost 1.5 decades now, among other things, constitutional law. And it's an immense privilege to teach constitutional law, I think, especially now. And I think such a subject cannot be taught well, or can only be, in a context like ours, must be taught subversively. I think it's impossible to teach constitutional law in Uganda or in any other hybrid democracy, for lack of a better term, without being very clear as to the role it can play in pushing back against those who would create dictatorships and entrench them. So I think the legal education that is fit for purpose in 2025 in Uganda must be a radical one, must be a subversive one. And this is where Semakade's discussion around the radical new bar, I think is particularly apt. Now, last year, for instance, Professor Loko Onyango, myself, and our colleague were responsible for setting an exam that was complained about by the Speaker of Parliament, Honorable Anita Among, and was actually almost became the subject of an investigation. And I guess the idea was to have us expelled. For me, that was an important moment in terms of legal education in Uganda, and for me, it signified that we're doing something correct. Because if you're teaching constitutional law, practicing constitutional law, or practicing law in Uganda, nothing happens to you, and there's no threat to you, then there's something you're doing wrong. I took that as a badge of honor. And today, Adaobi, I'll tell you that the constitutional law exam that was sat this morning by the students at Makerere Law School was one that reflected the entirety of the difficult times constitutionally that we're going through. It was a problem question, question number 3. But that question number 3, I think, really spoke to the very situation we're in and is already being discussed, I can see, on social media and elsewhere. So I think that's the way forward, a legal education that is courageous, that is radical, that is subversive, and intentionally so. And this speaks again to the point made by Professor Chidi and Honorable Karua about the limits of the law and the importance of again, intentionally utilizing the politics of the law, politics small p, to push back against those who are, in any case, also politicizing the law nefariously. And so in the Kizza Besigye case and cases of that nature, there's a lot to be done in the courtroom, but also done outside the courtroom. But also, it's so critical to understand the courtroom as a site of political resistance. And I think that's something Aaron Kizza did powerfully in the Besigye case, to make it clear, to use the courtroom as a site of political resistance, to make it clear to both the judges, to those speaking to the judges behind closed doors, that we see through them, we see what they're doing, and we see it for what it is, a farce, a sham, and to call it out. And I think ultimately, political cases such as Besigye's must be fought both legally, politically, but also they must be fought basically in 2 or 3 arenas. And I think that's being done quite well. I think I'll leave it at this for now.
Well, thank you so much. That is very, very encouraging. The idea of really empowering young lawyers right from school, and the thought that what was taught in school created political tension is interesting, because that means you're doing something great. So thank you so much for that complete realization, and also imputing that as you engage with students. I'm looking at the time, but I see questions. I'm just going to quickly take a few questions and then we wrap up. There is someone asking in the chat room. Let me see. Are there non-purely legal measures that can be explored in these circumstances? Is there any thoughts here?
Would you like any of us to answer?
Yes, either you or Professor Chidi can take that.
Specific to someone? Yeah, there are other legal channels, courts, and I know that Aaron Kizza had filed a case in connection with the Besigye case in the East African Court of Justice. And I know that now we have instructions to file a case in Kenya against the Kenya government for the illegal rendition of Besigye and Lutale. So we can have options in the regional courts, because it's also a violation of the African Charter on Human and People's Rights. It's a violation of the Constitutive Act of the East Africa Community and of our respective states. So using the court, as it has been indicated, as a site of political resistance, filing those cases increases awareness and brings pressure to bear, and also sharing this information with as many as possible. Allow me to also mention that, yes, there are senior lawyers, Ugandan lawyers, in the Besigye case. One of them is the Lord Mayor of Kampala, Erias Lukwago, under whose chamber I practice. There is also a lecturer, Ernest Kalibara, and his partner. And there is a lawyer who now has become a member of parliament for Kawempe North, Narukola. And there are many others. I may not know exactly each person's seniority. It is so that it doesn't look like we are saying no senior lawyers have come up. They're there, and their presence is important because they're able to articulate and to resist being pushed off or wished away or being stopped from submitting by the court. I think I have answered your question, and I'll be seeking to leave a little earlier. So unless if there's another question, I'm seeking permission to leave.
No, we're actually rounding up now. So Dr. Chidi, I see a question that you may want to quickly take on that talks about Ken Saro-Wiwa in constituency building and advocacy in Africa in modern times.
Well, first of all, the role of a lawyer in this, at the end of the day, is actually not easy. There are ethical challenges, and I think this is one of the areas where we've also got a responsibility. I mean, in addition to solidarity, it's also about the skilling up of ourselves. There is your primary ethical responsibilities to your client. And what to do, what mix of skills and forums to bring to bear on any particular case has got to be done in close consultation with the client, because you don't want to leave the client behind. I was involved in the Ken Saro-Wiwa case. as a much younger lawyer. And the decisions were not very easy. They were ethically quite challenging on many fronts. We don't have the time to discuss them now. But yeah, we ran the whole gamut of the world. I was basically funneling people across the world in the campaign on that case, from the UK, the United States, the New Zealand summit of the CHOGM, South Africa to meet with Deputy President Mbeki at the time, and the rest of the world. And as I like to tell lawyers generally, we are not before one court in cases like this. You find yourself before a court of law, and you also are before the court of the Lord, and you're before the court of posterity. The thing, most of the time, the state wants to confine you to the court of law because it is their court. And as the lawyer, you've got to litigate beyond their court, and constructing that forum and creating that forum before which you do that is what matters. This year alone, at least I've written 2 people out of very bad cases in Nigeria. The Dele Farotimi case, for instance, we basically won outside the court because that was a case of somebody abducting a fellow citizen and a lawyer at that and bringing them to his forum where he wanted to destroy him. And just by being able to show people that the crime did not exist, that turned the tables. It made it impossible for them to resort to law for that purpose. So we've got to trust the people on a lot of these issues. Part of the problem we've got, and I'm glad you asked that question, is twofold or maybe threefold. One, as lawyers, we are taught not to communicate with our people. The court is a political forum. It's not a technical place where you go to speak Latin that nobody understands. So we've got to break. Litigation is storytelling, and we've got to teach lawyers. If I had to redesign the law curriculum again, teach lawyers plain communication and narrative skills. Clear narrative skills. That's very important. And you're using the court to tell a story to the world. Tell it in a way that makes sense in the 21st century. That's number one. Number two, stop this nonsense that they taught us that the British gave us independence of the judiciary. They did not. Independent institutions are fought for. Our courts are not independent. They never were. You do administrative law, they teach you that you got independent judiciary. You do constitutional law, they teach you got independent judiciary. It's a lie. So we've got to start telling our people that we were taught lies. Okay? Changing that and teaching the younger lawyers, we don't have independent institutions. We have to fight for them. Begins a popular political process. It's a different way of teaching law. And unfortunately, not enough of us do that. I'll end with a story. Not from law, actually. In 1964, there was a mutiny in Tanganyika. Julius Nyerere abolished the army in Tanganyika. And for 9 months, Tanganyika did not have an army. When he recreated the army, he recreated it as what? A People's Defense Force. That is why Tanzania began the People's Defense Force. Now, I have my problems with that, but have we ever thought of recreating our law as a people's law? And what will that look like? That is the challenge of all of the law lecturers and senior lawyers here. How do we recreate our law in a way that connects with the people? That's why Museveni is beating us. I yield.
Thank you, Prof. Thank you. Teach lawyers plain language, plain communication and narration. Independent institutions are fought for, and people's law. Very, very apt points. I've noted them down, and as always, the Chidi in action. Thank you so much. We're going to prepare to round up. I see there are comments in the chat box and the idea of this discussion. This is the beginning of many discussions that we hope to have on different issues. In rounding up, I'm just going to ask my panelists to just give us 1 minute's close of thoughts, as this is a series that we want to continue in different countries. Just give us 1 minute summary and closing, and then I'll hand over to Ike Chukuzoma from RFK to close off us. I'll start with you, Honorable Mata.
Oh, for me, I would just say that the problems we are going about politically motivated cases and other forms of repression, it is up to us, the professionals in our respective countries and in the continent, to push back. And it doesn't matter which space you occupy. If you're in the court, do what is right. If you're in another space in government or in institutions, do what is right. If you are in private practice or in a space where you can show solidarity, let us show solidarity internally and externally. And as Professor has said, let us use communication. Let us communicate with the world, because even repressive regimes don't like to be called out and don't like people to know how they are taking shortcuts to the law. Thank you for this forum, and let's keep up doing what we can for the continent. Thank you.
Thank you so much. Professor Chidi.
I really don't have anything to add to what Honorable Karua has said. Thank you very much to you and the colleagues at Vance Center. I see my boss, Ike, there as well, and I saw another boss. The question you asked actually is from another boss, Chepkori Sambu. And it's good to see that there are different generations of African lawyers in this conversation. I hope we grow the generational exposure and inclusion, but also the regional exposure and inclusion. This has got to continue, however we do it. And let's try and reimagine both the law as a space for struggle and legal education as a capability through which we can advance that struggle. And just to say to Enron and the colleagues in Uganda, keep strong. It's not easy, but we can. All these people are trying to do is make us all give up on our countries. It's not going to happen. Full stop. Period. Thank you.
It's not going to happen. Thank you. Dr. Kabumba.
I was told not to speak when there's nothing more that can be added, and I don't think I should really. It has been really neatly summed up. I'm grateful that these planned as a series of conversations, and I look forward to more of the African Rule of Law series. I also look very much forward to hearing from Aaron Kizza, Philip Karugawa, and the rest of colleagues of this forum. I see Abubakar Sekanjako, who incidentally sits on the Judicial Service, on the Law Council of Uganda as a representative of the Law Society. So it's and of course other colleagues from all over Africa and the world. For instance, it would be interesting also to hear. I don't think it's something we touched upon, but part of the challenges we now have, and part of the boldness we are seeing from Muhoozi and others, is about what has happened in the United States with Trump. So it might be interesting to see the link between the erosion of democracy in the United States, the clear erosion all over, almost it's bold, it's increasing impunity, it's shamefest, it's in your face, and the message that is sending across Europe, across other places in the world, the carte blanche it's giving for dictators and would-be dictators to run riot elsewhere. And perhaps that's a very important conversation also that needs to happen at some point. Thank you very much.
Thank you so very much for that important closure. And the idea of this was to also ensure that issues of this magnitude happening in Africa is not swept under the carpet with all that is happening across the globe and all that we hear when it comes to democracy and rule of law. I just want to say a big thank you to my panelists for being here. We know how busy you are, but this is not for me to round up. I'll hand over to Ikechukwu Zoma from RFK to give us a closing remark and really round up. But I really acknowledge a lot of people I see in the chat box, senior lawyers from Uganda who have taken time out to join and contribute to this. Your solidarity matters to us, and we are grateful. Thank you so much. And Ikechukwu, over to you, please.
Yeah, thank you. Thank you so much, Adaobi. And I want to say thank you to Professor Chidi Odinkalu, to Honorable Karua, and Dr. Kabumba for this amazing conversation. It's been quite inspiring and it's been encouraging. I think what is clear is the fact that we actually can be a lot more than these challenges that we face. And if it was a game of numbers, the rights holders, the people, always retain the power. But sometimes we need to take a step back and re-strategize. And I think that's what we are doing today, just to learn from what has happened and to figure out how we take steps further. But just like the real boss, my real boss, Professor Odinkalu said, they want to get us to stop, and we have to make a decision not to stop. But we would not continue in just for the sheer reason, for the sheer cause of continuing on the path. We'll continue with precision, we'll continue with knowledge, we'll continue also by learning from the what has happened in the past and ensuring that it's even amplified by the tools we have, including technical and other tools that we have to advance advocacy broadly, because even litigation is advocacy, just like we've discussed today. But from the courage of Dr. Martha Karua, an example that she's shown, to the great insights that has come from Dr. Kabumba and the great work that's happening at Makerere University, to just the insight and wisdom from Dr. Odinkalu, I think we've had a phenomenal conversation. I'd like to thank the over 100 people who have been in and out of the room and have contributed through your conversation, through your chats and your investment. There's a link for you to join the mailing list for the Vance Center so that you learn about future events and you can join. And the hope is that these events would not just be talk shops, but would be the real strategy sessions that would begin to spark up ideas on how we begin to engage at the grassroots level and begin to ramp things up also at both the national and the regional level. So let me now also thank the Vance Center for International Justice and Adaobi and the colleagues for the leadership in putting this together. Our dear colleagues at the Pan-African Lawyers Union, the New York City Bar, and of course, Robert F. Kennedy Human Rights for putting all of this together. And until the next one, I'd like to urge you to stay safe, but also stay hopeful, and let's keep pushing.
Thank you so much, Ikechukwu. Thank you, everybody, for joining us. Look out for the next discussion with different countries, and we'll keep the discussion going. Subscribe to the newsletter, and you get our monthly update, and then we'll be updated. We look forward to seeing you again. Thank you so much, everybody.